Good morning, everyone. Thank you for joining us for our seminar on want of knowledge and approval. It's damp and grey and miserable where I am, so I suspect probably the same for everybody else. So we will hopefully be able to stay warm and enlighten you a little bit more in respect of want of knowledge and approval. So I'm going to just do a brief introduction as to the law, as to what want of knowledge and approval means. Then Chris is going to talk to you about undue influence, and Julie is going to talk to you about costs. At the end, there should be time for questions. So if you do have any, please feel free to ask, specifically related to want of knowledge and approval, really, rather than more broadly, but we'll see where we go. So I just wanted to talk about the nature of contentious probate, because we call ourselves, or those of us who practice in it, contentious probate practitioners. And by that, we likely mean something quite broad, so encompassing contentious estate administration, the removal of dodgy trustees and personal representatives, claims under the 1975 Inheritance Act, etc. But a probate claim proper is as defined under Civil Procedure Rules Part 57. And we're talking about the grant of probate of a will or letters of administration, the revocation of such grant, or a decree pronouncing for or against the validity of an alleged will, which is not non-contentious business. And by non-contentious business, common form business, we mean the applications for grants of probate in the probate registry. So probate claims are slightly unusual in nature. So they are issued Part 7 because they must be, but you can't get default judgment if the defendants don't defend. In most other types of litigation, if all the parties are grown-ups and all of them have capacity, they can settle on whatever terms they deem appropriate for them. But that's not quite the case in probate. You have to go through certain rules to either get a discontinuance of the claim or a dismissal of the claim. So it's slightly distinctive to the other types of litigation that we get involved in. Another example of where it differs is that defendants who don't want to put in a positive defence, but want to put a claimant to proof, essentially, will be protected in costs if they put in a passive defence. Even the probate registry has special requirements of oversight. So the registrar themselves can refuse to admit a will to probate if they consider that there are inquiries that they themselves should make. And the reason I just want to do this broad overview is just to explain that whilst we consider ourselves adversarial advocates, we are in an adversarial system of litigation in this country, where the task of a judge in an adversarial court is to do justice between the parties in terms of the ways in which they have framed their cases. The judge is adjudicating, refereeing the case between them. And if one side doesn't put a point, whilst the judge might be able to suggest that they recast or modify their case, if they choose not to do so, the court must respect that, because the judge is not descending into the arena. It's not their fight. That's not quite the case in probate claims, because the court wears an inquisitorial hat, because the court is actually trying to search out the truth, because the protagonist, the main witness, the key witness, is dead, can't speak from the grave, and so the court wants to make proper inquiries to try and search out the truth of what the testator meant. Now, whether or not the court finds the truth is, of course, a very different issue. So if we can just, Chris, if we could just have the first slide, please. So I just want to address you very briefly on want of knowledge and approval. Right, I hope everybody can see the slide that I can see. So want of knowledge and approval in a nutshell. In Gill and Woodall, which is the 2010 decision, Lord Neuberger said that wills frequently give rise to feelings of disappointment or worse on the part of relatives and other would-be beneficiaries. Human nature being what it is, such people will often be able to find evidence or to persuade themselves that evidence exists, which shows that the will did not, could not, or was unlikely to represent the intention of the testatrix, or that the testatrix was in some way mentally affected so as to cast doubt on the will. But if judges were too ready to accept such contentions, it would risk undermining what may be regarded as a fundamental principle of English law, namely that people should, in general, be free to leave their property as they choose, and it would run the danger of encouraging people to contest wills, which would result in many estates being diminished by substantial legal costs. So the person seeking to propound the will, to prove the will, to probate the will, must prove that the testator knew and approved of its contents at the time they signed it. Ordinarily, knowledge and approval will be inferred where, firstly, the testator had capacity, and secondly, the will was duly executed. Again, returning to Lord Newburger in Gill and Woodhall, he said, as a matter of common sense and authority, the fact that a will has been properly executed after being prepared by a solicitor and read over to the testatrix raises a very strong presumption that it represents the testatrix's intentions at the relevant time, namely the moment she executes the will. Now, sometimes there will be circumstances which raise a suspicion in the mind of the court, and starting by it being in the minds of the disappointed beneficiaries. And more will be required to discharge that burden that the testator or testatrix knew and approved of the content of the will. Suspicion will be aroused to varying degrees, and depending on the circumstances, what will be required to dispel that suspicion will vary accordingly. And what the court does with its inquisitorial hat on is stands back. It looks at all the relevant circumstances to examine whether the document before it truly represents the testator's testamentary intentions. Suspicions can be arised in different ways and in different manners. So some circumstances exciting the suspicion of the court are, for example, where a substantial beneficiary or the major beneficiary is the person who had an active part in writing the will. Often fears of something having gone badly wrong occur where there has been a marked change in the provisions of a will. So, for example, mum had always throughout her wills left the estate equally between both daughters, and then suddenly one daughter is excluded, or her long-standing prospective inheritance is cut down. That raises a suspicion that the other daughter had a hand in that. Suspicion is also aroused, for example, where the language is not that of the usually used by the testator. Frequent examples arise where English is not the testator's first language, but there's no attestation clause showing that it had been read over to him before it had been executed. So if the language is different, or if people are referred to, for example, by different names, then that's one way that suspicion can be aroused. And then, of course, we have gifts to persons in position of influence over the testator. There are different requirements applying, of course, if there's a solicitor who is left a gift in the will, and there's SRA and all Law Society guidance about the circumstances in which gifts can be given. Dispelling suspicion. So one person raises it and the other person answers it and says, well, no, look, the person had capacity and it's duly executed. The language is normal. The solicitor read it over to them. A professionally prepared will is obviously going to, in most circumstances, have a greater layer of protection than a home prepared will, and particularly those which are prepared by, for example, will writers, where a questionnaire is sent out and filled out, and the person drafting the will may actually never have any contact with the testator beyond perhaps a telephone call. And the will being read over by somebody independent, i.e. the solicitor, or somebody who doesn't take any interest in the will. So we're moving on to the final slide then on this in this section. So it's a one-stage test. So we can talk about presumptions, we can talk about raising suspicion and dispelling suspicion, but what the court does, as I've said, is step back and makes its inquiry. It looks to the totality of the evidence. It considers all the relevant and admissible evidence, drawing inferences where it can, and of course not speculating, because that is impermissible. So it looks at the totality of the material to come to the conclusion, binary conclusion, as to whether or not those propounding the will have discharged the burden of establishing that the person who made the will knew and approved of the contents, which is being put forward to probate, i.e. to proof. So therein ends my section, and I'm now going to hand over to Chris, who's going to address you on undue influence.
Good morning, everyone. And may I say a big thank you for joining us for this webinar today. For those of you who I haven't met, my name's Beneducci. I'm 2015 cool, and I do private client property and insolvency work at Selborne. My subject today is the relationship between want of knowledge and approval on the one hand, and pleas of fraud or undue influence on the other. This is an area which can trouble judges and opposing lawyers who may not be contentious probate specialists and are having to deal with it with what is undeniably quite a niche cause of action. The nub of the issue here is that, as you will have sensed from that list of suspicious circumstances, a challenge to a will which is based on want of knowledge and approval can and often does engage exactly the same facts as a challenge based on fraud or on the narrow testamentary doctrine of undue influence. And I've tried to draw out these overlapping causes of action with a short example. So say, for instance, that you believe an unscrupulous solicitor, suggest perhaps from the Suffolk and North Essex Law Society, has slipped provision which massively benefits them into your grandmother's will without your grandmother realizing. Two options present themselves. You can challenge the will on the basis that it doesn't reflect your grandmother's testamentary wishes because there was a fraud, there was intentional deception, a knowingly wrongful act. That's one option. Alternatively, you can allege that the will doesn't truly reflect your grandmother's final testamentary wishes because she didn't know and approve its contents at the time that she signed it. How to choose between those two options? If you want to establish fraud at trial, you'll bear the burden of doing so, and you'll likely pay the other side's costs if your challenge fails. On the other hand, if you allege want of knowledge and approval, then it's the propounder who bears the burden of proving that there was knowledge and approval. And even if your challenge is unsuccessful, you might hope to avoid an adverse costs order on the basis that the circumstances reasonably called for investigation. So on precisely the same fact pattern, there are very significant advantages to choosing a plea of want of knowledge and approval over a plea of fraud or undue influence. And in fact, as I've noted on this slide and in the handout which will circulate after the talk, this is a kink in the law which the Law Commission has noted and which it's keen to iron out, albeit the Law Commission's proposal is to broaden the testamentary doctrine of undue influence so that more claims are framed using that cause of action rather than perhaps distorting what want of knowledge and approval does in this context. So if that's the general background and the issue which has arisen here, what is it that troubles judges? And this can sometimes be a speed bump in submissions or in the course of correspondence, and so it's useful to have the key cases to hand. If you're saying, to continue my example, that your grandmother didn't know or approve the bequest to her solicitor, then the strong implication is that you're alleging the solicitor acted fraudulently in slipping that particular bequest into your grandmother's will. Certainly, it's difficult to see how that bequest could have got there innocently or even negligently. Putting it differently, and this is how it quite often comes up in the reported cases, in this scenario, faced with the challenge, the solicitor is likely to say, well, the testatrix asked me to include that bequest in her will. And so if that's the solicitor's account, and if the judge finds against them on that account, then that's tantamount to a finding that the solicitor is guilty of fraud. So the question which arises is, given the clear implications of your case theory, shouldn't you actually be pleading fraud front and centre? Are you guilty, as counsel put it rather dashingly in this case of Re R, of being willing to wound but afraid to strike? The short answer when it comes to this question of do you need to plead fraud is no. And that was decided by the House of Lords a decade after Re R in the case of Wintle and Nye. Wintle and Nye is interesting for any number of reasons, not least because the plaintiff in the case, Lieutenant Colonel Nye, was actually a stranger to the estates, but he took an assignment of an interest in it because he was so fueled by a sense of injustice. And then, acting in person, he took the case up to the House of Lords where he was successful. To make it even more impressive or bizarre, he'd actually spent 6 months in prison prior to the case kicking off because he had physically assaulted the defendant in literal pre-action skirmishes. So there's quite a rich context to this case, but for our purposes, the key point to draw from it is the one I've put at the first bullet point on this slide. What this means is that if you are running a plea of wanted knowledge and approval, you can cross-examine on the basis of deliberate misconduct, but you don't have to actually plead that specific allegation when framing your case initially. You may have views on how appropriate that is or how coherent the law is in this respect, but nonetheless, it is the law and it was established by the highest courts some time ago. That said, you will from time to time see in the cases the sort of moralizing comment from judges that Lord Justice Macomb made in Burns and Burns. They're talking about a cloak to conceal another type of claim. The difficulty with that sort of comment for me, though, is understanding how far it actually goes. So if something you're alleging plainly only goes to fraud or only goes to undue influence, then fine, you should put that properly and explicitly as the rules require. But given the breadth of the court's investigative jurisdiction when it's asking about wanted knowledge of approval, it's hard to see how many allegations will actually fall into that discrete category of only relating to fraud or only relating to undue influence and not having a bearing on knowledge and approval. So, as I suggested to start with, in contentious probate cases, the matters in issue are very often going to straddle knowledge and approval, fraud, and undue influence. So they can't be divided up in such a neat way. That means that even if there's some judicial and academic discomfort about the extended role knowledge and approval has come to play in probate litigation, all the same, it is a card which is open to litigants to deploy, and they shouldn't be prevented from doing so. For demonstration of that inaction, I can turn to last year's case of Reeves and Drew, where Selborne's very own Clifford Darton KC successfully ran a plea of wanted knowledge and approval. Now, I've put quite a long quotation on the slide. I won't ask you to read it all now, and these will be circulated after the seminar, as I mentioned. The one point I would focus on, though, is the final paragraph, which I've highlighted. There, Mr. Justice Green said, "Accordingly, my task is to assess by reference to the totality of the relevant evidence before me, whether the claimant has proved on the balance of probabilities that the deceased knew and approved of the contents of the 2014 will." That, I would say, is an unimpeachable summary of the court's exercise when it's looking at knowledge and approval, and also a reminder that that exercise is, in essence, a simple one. So bearing that simplicity in mind, I'll now hand over to Julia, who talk about some rather less simple cost consequences and other aspects of the doctrine.
Good morning, everyone. I'm Julia Beer. Mainstay of my practice at Selborne Chambers is contentious trusts and probate, and I have a particular expertise as well in farming estates and those that involve shareholdings. I want to talk to you today about costs, but before we get there, I also want to just highlight something which I think is often overlooked, the fact that there can be want of knowledge and approval of part of a will or part of a testator's testamentary disposition. It's important to remember and remind ourselves of the three parts of the test. What the court is looking for when it is adopting its quasi-inquisitorial function is to be able to answer three questions. Firstly, did the testator understand what was in the will when he signed it? So we are looking at the actual point in time when the will was actually executed. Secondly, did the testator understand what its effect would be at that time? And thirdly, can the courts therefore conclude, this is the controversial part, that the will did represent the testator's true testamentary intentions? So these are the same legal principles which apply when you are looking at the will as a whole, as much as when you're looking at specific gifts within the will. Now, if you look at that in context, there has been a recent case, which is the Rishi Fontaine Grizzle case, and the details of that are in the handout, which will be circulated, where perhaps controversially, when the judge looked at the will as a whole, found that the testator didn't have sufficient knowledge and approval to understand the operation of the residuary estate in that particular case, but perhaps controversially was found to have had sufficient knowledge and approval to have understood a far more complicated will trust, which was executed as part of the will over his own home. So I think that just puts it into context in terms of when you are looking at potentially challenging a will, it is important to look at every aspect of it and every gift which has been made by the testator in that context. Now, I put up on the slide the famous quotation from Lord Justice Gibson, that looking at where a situation can arise where only part of the will can be upheld because of lack of knowledge and approval, he suggested could be described aptly as a curate's egg of a will. In other words, that it is extremely rare. In my experience, I don't think that that is the case now, and I don't think that these challenges are perhaps quite as rare as Lord Justice Gibson perhaps articulated in 2001. Turning to the case of Skillet, for example, Skillet 2022 case, EWHC 233, Chancery Division. That reference isn't in the handout, so I'll just give that to you now. But this was quite an interesting case as well, because one of the grounds of challenge that was made in that particular case was want of knowledge and approval, again, of part of a will. And what had occurred in that case was that there was a gift that the testator had made of a plot of land to one of his children. And that land had increased in value because of the passage of time between the point when the will was executed and obviously the time when the testator had died. And the result of that was that there was then a gross inequality in the value of testamentary gifts and how the deceased ultimately had then made provision in his will. And the children said, well, this can't have been what their father had intended, and therefore the will didn't represent the testator's testamentary intention. And that was the argument which was ran. But the court was quite clear when looking at this that just because there has been a passage of time and there has been a departure in terms of how ultimately the estate ends up being divided upon death, didn't in that particular case undermine the testator's knowledge and approval of part of the will. And I think that is an interesting comparison, going back to the Richifont and Grizzle case, which I mentioned earlier, because again, the same, arguably the same difficulty had arisen because of the passage of time between the time when the testator executed the will and actually what had happened by the time the testator died. Because in Richifont and Grizzle, at the time the testator executed his will, he had virtually no value in his residuary estate. But what he did have was he had a property which he still held with his wife, who he'd been separated from for a number of years. And he believed that, as was the case, that he would that property would pass by survivorship, and he believed that his wife would outlive him, and that therefore the property would therefore devolve to the adult children of that relationship, and that it wouldn't form part of his residuary estate. And what happened in that case was that, in fact, the wife died first, and he received a windfall in that context, and it fell into his residuary estate. And at the time that he executed his will, he'd made no provision at all for his adult children, and they weren't beneficiaries of the residuary estate. And so they essentially took nothing under the will, and what he had intended at the time when he made his testamentary disposition, as it was held by the court, was that he had intended that his adult children would benefit from that property, and therefore the will didn't give rise to his true testamentary intention. And it was found that, in fact, it hadn't been fully explained to him at the operation of the residuary estate. So I just pull these two cases out and put them side by side, because I hope just to illustrate to you that it is worth, as I say, just looking at every aspect of a will when you are looking at a potential challenge under grounds of want of knowledge and approval. The other short point is about legal jargon, because often it will be said that the testator couldn't possibly have understood the jargon which was used in a will. And of course, they often, of course, when they're instructing solicitors, and solicitors will adopt the usual language, and a challenge is made by children, often children, afterwards on the grounds that mum or dad couldn't have understood that language. Again, it is not necessary for the testator to have understood every part of the sort of legal jargon which is used, but really it will turn upon the quality of the explanation which is given by the will writer. And going back to the Richifont and Grizzle case, that was a case where the blame was put squarely at the door of the will writer by the court for the will writer's failure to have given an appropriate explanation of the operation of the gift of residue in that case. So just pulling all of that together, but particularly if there was a complicated family matrix that sits behind what the testator's intentions, or indeed the estate is complicated, it is I think prudent to just look at every aspect of the will if that there are points which perhaps do lead to potentially an unfairness or an unintended consequence when you're looking at this, if you're asked to consider that by your clients. So if I can just move on now to costs. In probate claims. Can I have the next? Oh, perfect. So I just wanted to just spend 5 minutes really reminding everyone and dispelling the myth, which I think still does exist, that executors' costs are always paid out of the estate, and that isn't the case. And I just want to take, as I said, 5-10 minutes just to go through and remind ourselves of costs in probate claims. CPR, of course, applies to a probate claim in the same way as any other civil litigation. But as you will undoubtedly, I'm sure, be familiar with, there are special probate rules of costs which can apply in certain cases. Spears in English, which is in the first column of the slide, is of course the famous authority where the court identified 2 exceptions. In other words, 2 exceptions where the usual costs rules can be disapplied if your case falls within either of those. And the Spears in English decision was, of course, more recently upheld in the case of Costick and Chaplin, the 2007 case, where Mr. Justice Henderson, as he then was, of course, took those principles and brought them and updated them, and essentially reminded us that it is the consideration of policy and fairness which underpins these exceptions in the Spears case. And the reason why these exceptions exist, and they sit outside of the CPR to that extent, is going back to what Lydia said at the outset and reminding ourselves that, of course, the court in this case is adopting the quasi-inquisitorial role in probate claims. So the first exception there is when it is found that it was actually the deceased is to blame, or the deceased was to blame. The touchstone is whether it is the testator's own conduct which has led to his will being surrounded with confusion or uncertainty as a matter of law or as a matter of fact. So the question really is it the testator who's caused this, and is he, or does the blame lie elsewhere? And when you are considering that, it's also important to remember that, of course, the testator's actions does extend to the will writer, because it's the will writer who's acting as the testator's agent. Again, going back to the Richifont and Grizzle case, that was very much what the court reminded everybody of, and the fact that it was the will writer that, in that case, had caused the confusion and the difficulty. The second exception is where the question is posed: do the circumstances lead reasonably to an investigation of the matter? The premise, of course, being that if circumstances reasonably lead to an investigation into the validity of a will, that an unsuccessful party shouldn't be condemned in costs. Again, this quasi-inquisitorial role which the court is taking on. Now, this undoubtedly, in my experience, leads to an interesting tension and overlap between what steps are necessary, sort of pre-action, as it were, to reasonably investigate the validity of the will, and at what point does it turn into it is now reasonable to litigate the validity of a will. And that is quite a careful balance to tread. And it may be, as has been in various cases, that it is reasonable, for example, to investigate the circumstances surrounding the will, perhaps sometimes up until the exchange of witness statements of fact. And at that stage, it might be that the position is sufficiently clear that it can be said that a line is drawn at that point, and then the exceptions would fall away, and then you're into the usual hostile litigation. It may be said that just upon receipt of a properly raised and answered Larkin-Nugis request and statement, that point may be reached. And actually, you are in, if you were to litigate after that, that you are in the territory of hostile litigation thereafter. And it's important to note that the Spears exceptions, they're not exhaustive, they're not rigidly prescriptive. And of course, the reality is that litigation carries with it cost risk, which I think, as I said at the outset, I think there is a myth still that executors can almost do as they like, because there is this, I think, still this misconception that executors' costs will be met by the estate come what may. And of course, once you're in hostile litigation, it's the usual rules of CPR 44 that will apply on a final determination of costs. Second column I've put in there is just to remind ourselves as well of CPR 57.75, and that of course the position is that if of course the executor or the follows the correct course, as it were, and if they do want to need to issue a probate claim, really for their own protection, to prove the will in solemn form, that it's this the neutrality and the passive defence is really obviously important, not to lose sight of that. Reminding ourselves of the position of executors more generally, it is of course the case that there is no duty, an absolute duty after all, on an executor to prove a will, and the position can sometimes become difficult where you have executor beneficiaries, and whether it is ever appropriate for an executor beneficiary to issue a probate claim, and if so, to really take the appropriate steps so that they are moving forward in a position of neutrality and not acting for the benefit of themselves, but always to be seen as acting for the benefit of the estate. And that is a key distinction which needs to be, everybody needs to be reminded of. Really, it's for an executor beneficiary to simply issue a claim form, join defendants and the necessary defendants, and then really to step back and to adopt the neutral position. Going back to the case of Richifont and Grizzle, that also produced, because of what happened, quite an interesting costs position. And again, really does sound a note of caution to executor beneficiaries. In that case, there were 3 executors only one was had a benefit from essentially propounding the will. The other two were neutral. But essentially, what the court found was the court partially upheld the will. The will was actually propounded in solemn form, save for the residuary and the state, for the reasons that I mentioned earlier on. But in that case, the executors were held not to be entitled to have an indemnity from the estate, because the court was able to find that they had not acted for the benefit of the estate as a whole, and instead had acted for the benefit of one of their numbers. So while two of them didn't have anything to benefit from the will being proven in solemn form, nevertheless, one of the executor beneficiaries did. And that was sufficient to essentially tip the costs, there being no cost orders as between the parties. And the executors were not entitled, therefore, to the indemnity from the estate. And of course, what we all want to see when we have executors who are issuing probate claims, we want to make sure that they are caught within CPR 46.3 as far as possible. And that general rule, which is that the executors or the trustees are entitled to be paid the costs of proceedings insofar as they're not recovered from or paid by another person out of the estate or out of the relevant trust fund. And that is obviously what we ideally want to be able to achieve for our executors when they are issuing probate claims. So it is important just to have that at the back of your mind, and to just make sure that at all times executors are adopting an appropriate neutral position, and if necessary, of course, they will need to go and seek directions from the court before issuing a claim. But often, of course, there are issues of proportionality and to be considered before taking that step as well. So that's all I wanted to say on costs. So I will, I think, hand back over to Lydia and Chris.
Thank you. Right, well, I think we are now on at 10:15. So unless Chris or Julia has anything further to add, I'm going to throw open the floor to any questions arising in respect of knowledge and approval, or more broadly. So does anybody, or would anybody like to ask anything or open up any sort of discussion? And I will pause for the mass of hands going up and people fighting to get their questions before us. Well, unless everybody's muted, I'm going to take that as take that. No questions arising. Chris or Julia, is there anything that between the three of us it would be worth picking up on and discussing in any more detail?
Not from my part. We did we did run this seminar just for the benefit of the audience in person in London, and we did sort of pull together all of the points that we've discussed today in a sort of a problem question, which did actually promote quite a lot of discussion in sort of a 30-minute session afterwards. And I appreciate it's a little bit artificial, perhaps, sort of asking for questions here when we haven't sort of got sort of a live example, as it were, to go through. But I do hope that today's been useful, and we've managed to give you some tools for the next want to knowledge and approval possible case that does cross your desk.
I'd echo that. even though I described it as a niche cause of action, it is one that we will see in our practice fairly regularly. And if you do have any questions when it arises, we'll have the handout for reference, but don't hesitate to get in touch with us either to pick up any particular points. And all I can say is thank you again for joining us, and I hope you all have a good week.